Good evening, ladies and gents. Cyril Jacob here. Good evening to week 10, construction of a contract, implied terms. This is where we have a contract and for some reason, we need to bring a further term in, which has been implied. Look, we've got two types of terms. We've got those to correct, which seems to be a mistake by the parties. Another one would be to accomplish requirements imposed by the law. So we'll go through both of those. So let's just quickly go through this and then we'll do the tutorial question. So of the two types of implied terms, let's look first at those implied terms giving effect to the intention of the parties. So basically looking at a term as if it was there. And I really think you should be looking at the lectures as well, Anthony's lectures, because they're quite good. They paraphrase his notes, but it gives you a good feel of what's happening. There he says, the first category, there's four categories. The first category, oh, by the way, see as in the past, what I've done, I just put them on a flow chart. And it's just so easy to do it that way. Terms implied to complete the contract. So, as I said, we don't ordinarily imply a term of reasonableness or to do this, but on occasions, and you'll see the York air conditioning case in the Commonwealth. Either of you, any of you three, know the facts in that case?
Yeah, that's the one during war.
Yeah.
Yeah, and they were doing the works and then they came back to them afterwards because they were dealing with a cost plus and said, you've been overcharging us.
Good stuff. And they were saying it was incomplete contract and the Commonwealth pursued. And the government said, look, there is a term of reasonableness, so that they can imply this in. But you have to be careful that you don't make the contract up for the parties. And also, as you remember from the notes and the lecture, that this is not such a prevalent type of way of doing things. A more prevalent one is terms implied from a consistent course of dealings. I see the others probably don't have any voice here. I can see that they're there. We've got.
Can you hear me now?
But Daniel, hi. If you want to say something, would you like to talk about terms implied from a consistent course of dealings? Or anyone, Darren?
I think
there you go. I've just gotten on. What are you up to?
We just got terms implied from a consistent course of dealings. Remember the Hayes and Motorline case?
That's that's where they were consistently doing the same dealings over a period of time, and then there wasn't damage to some equipment they wanted to claim. They said that was that one the damage?
No, that was the that's the Crane case. This is where I'm Hayes, the employment.
Oh, the employment, of course, the employment. Yeah, that's right. And it was about the. Sorry, I buttoned in there. Yeah. It just sparked my memory. Because then one of the fellows got employed by a company, by an associate company of who they employed with, and the terms were that if it was within a 12-month period, they get a kickback for it.
Good. And what was the legal problem?
There was 10 occasions where there were after the fellow was supplied, they sent the paperwork to cover the whole the aspect of if he's permanently employed. So because they'd done it for so many times, even though it wasn't a contract in a strict sense, they were well aware of it.
Yeah. So let's say, Daryl, that you are Motorline and I'm Hayes. I send you a person, and afterwards I send you this contract. Are the terms and conditions in that particular document binding? If it's the first and only
If
case,
it was the
we've ever
first
had.
time, no.
No, there will be some sort of an agreement between the parties, pretty loose, but the terms and conditions in that contract won't be applicable. However, as you rightfully say, the more transactions you've got, the more it's likely to occur. Just while we're there, let's go back to Ollie Marlborough Court. Does anyone remember just the most brief facts of Ollie Marlborough Court?
That was about the fur coat.
Oh,
Beautiful. Well done. Now, she went into the hotel. It was a warm day outside. She decided not to take the coat when she went for a walk. She went out of the room, locked it, went for the walk and came back, and the room was unlocked. The coat was gone. They said on the back of the door there was a sign, and she said, I didn't see it until after the contract was made. Therefore, ordinarily, it would not form part of the contract. But if she had almost lived in the hotel, or or she was a wealthy person who travelled a lot and used hotels a lot, we could say, well, hang on, by a consistent course of dealings, of transactions, she should have been made aware of it. How does that sound? Because you should have been, you would have seen it. Remember Balmain New Ferry Company and Robertson? Does anyone remember the very...
Yeah, that's right.
Yeah, ferry entrance and exit fee.
That's right. Now, Mr. Robertson was a barrister, and the reason why he lost the case is that above the turnstile there was a sign, a penny to get on and a penny to get off. Now, if he was someone like, let's say, Borat, you've probably seen that funny film with Borat, the guy from Upper Uzbekistan coming out of Sydney, oh, I can't believe this place. You know, he's not expected to have seen it. But on the direct opposite, Mr. Robertson, who's been through there 20 years or so backwards and forwards, and is a barrister, and you expect the stuff to be understood. So you see, it's very important. Now, as you remember from the visual lecture and from the lecture notes, it's not just the number of transactions. What is the other item which is important?
The consistency. It's got to be the same type of transaction.
Exactly. So if you and I like Mrs. Ollie, the same transaction over and over, you'll say, oh, the more transactions, the more likely to be caught. But if you and I have a contract where every time it's radically different, that doesn't help. That doesn't help. Doesn't make it known that we can import those things in. So the law is never really clean and neat and tidy. And Anthony has this wonderful habit of making his tutorial questions always on the borderline. And because they're never, and the whole idea is to get us to think these things through. All right. The next one was terms implied from general custom or trade usage. The court may imply these into the contract. Okay.
Yeah,
Go on.
Didn't so much struggle with it, but in the industries that I've worked in, I struggled to find out what custom and usage really was.
Maybe there wasn't a real custom or usage at all.
Because I was just trying to think of in other jobs that I've done where there is something implied that everybody knows about, and that it's just automatic.
Now,
I just reckon that, I don't know, I couldn't quite come to any sort of examples of my own.
Well, we'd say in the construction industry, you'd use, for example, say a bricklayer. An industry standard gets $1.15 a brick to lay it down, and there's a lot of implied tasks with that. But he gets that as a rate, and the rest is implied, and that's a simple contract.
I'm sure most trades and professions and occupations would have a similar sort of thing. What happens if I said to you, Michael, we're having a party at the place, or not just Michael, Jason, so you're not feel left out, and Daniel and Daryl, certainly wouldn't want to leave you. You're all welcome to come. Each of you bring a dozen bottles. How many is a dozen? Not a trick question.
12.
12.
Unless it's a baker's dozen.
That's exactly what I'm leading to. But if we were in the baking industry, whatever you call it, and I said to you, Darryl, I need a dozen. How many would you give me?
Well, that'd be 13.
13. And they usually, that's for one for spoilage. That is the custom in that industry. Now,
Okay, yeah.
because you couldn't find a custom, either you're not deeply into that industry, which I'm not saying you are, or it probably doesn't have an obvious one in a particular area. I'm sure if we looked for it, we might find some, okay? But the case of a British crane in Ipswich plant hire, would anyone like to have a go at that one?
Well, that's where British Crane hired some equipment, crane equipment, and they put it on soft ground and it sank.
Yeah.
Yeah. So then they had to obviously try and get the crane out, and it's cost them, and they've damaged the crane, and they didn't want to pay for it.
Yeah. Now, the whole thing occurred because the two companies were slack and didn't get a proper agreement between the parties. Okay. And I must say, go back to earlier part of my career, that was, I'm not saying it was the usual, but a lot of smaller businesses, and indeed some larger businesses, did quickie contracts like that. Nowadays, they're in more detailed standard form contracts, and it doesn't happen as much. And also, the problem is, as we saw before, I'll go and hire the stuff, and then the document comes in afterwards. Well, that's not good, because there is an argument, particularly in the first one or two cases, that I wasn't aware of those. And the whole idea in the law is you don't saddle someone with onerous terms and conditions, them not being aware of it. And indeed, the more onerous they are, the more you have to make them aware of it. And I think we pointed that out last week with exclusion clauses, because I, as a tradie, I as this, I as that, I don't want to be liable for something, and I hide it somewhere. Well, you know, the English law doesn't like that. The law which we've inherited doesn't like that. That's good. Thank you, Darryl, because that gives a good feel. And while we're there in the notes, they're talking about the rules in order to incorporate into custom. They're the constant rules, and there's 4 of them there. Has anyone got access to those quickly? Those 4 rules.
Existence of a custom or usage that will justify the implication of a term into a contract is a question of fact.
Yeah, question of fact. Right. Next one.
This is the one that I was going on before. Is it must be evidence that the custom relied upon is so well known and acquiesced that everyone making a contract in that situation can reasonably be presumed to have imported the term into the contract.
Well, Darryl, I can say this to you, that I do a lot of corporate training, and I always take a box of chocolates with me, but you'll get a chocolate for that one, because it's an important point. Because if you can't point to a custom, well, you know, we can't use it, because that's the whole thing. It's supposed to be a custom. So it's a good point there. The third one?
A term will not be implied on the basis of custom if it is contrary to an express term of the agreement.
Do you think that makes sense? Anyone?
Yeah.
Yeah.
It wipes out the custom, basically.
Yeah, well, remember, what has been agreed upon between the parties is the express part. Why should an implied term, which the courts put in to fill gaps, overcome something which has clearly been so stated? I don't need to tell you that. It goes without saying, doesn't it? And anyone, the last one?
A person may be bound by custom, notwithstanding that he or she had no prior knowledge of it.
Yeah, and so people who go into a new industry can be at a bit of a disadvantage, you know. All right then. Now, the final one, and this is an interesting one because it's actually quite a voluminous one. Terms implied to give efficacy to a contract. Can someone tell me in plain English, what does that mean?
Right, just stopping you. Efficacy.
Sorry, Darryl, this is stressing you too much. I saw you running away, you know.
Gust of wind just blew me blasted sheets away. I just had to go get them.
Would someone like to have a go? Just tell me what that means in plain English. Terms implied to give business efficacy to a contract. Anyone?
That's when sorry.
Give Michael a bit of a chance. Otherwise, he's going to leave us. You know, we don't want him to lose him. You know, Michael.
Just so they can work together. Basically, it's so business etiquette at the same time. So you're not preventing someone. So there's the terms. You're not preventing someone from doing their job. You're allowing to do it.
Good stuff. Now, there are two very famous cases. Can anyone tell me what those two cases are?
One, Moorcock.
Yeah.
Moorcock or something along those lines about it.
With an M, Moorcock. Yep.
Yeah. Moorcock.
Yep.
Yep.
And the other one, what's the name of the other one?
Sydney City Council.
This one's BHP. Let's go through them both.
Oh,
Listen,
okay.
you're both you're doing well. So someone give me the facts of the Moorcock, because this is the seminal case in this area, and everything comes from there. So the Moorcock was a ship. What happened then?
This is the one where they wanted a jetty, so they basically moored one. They said, look, the water will recede and your boat will be on the floor. And they said, okay, that's fine if it's all right. Then when the water receded, it was on hard grounds and it damaged the ship.
Yeah, and nothing was written in the contract about the damage or the bottom, right? Everyone knew it's going to sit on the bottom, but they didn't realise it's going to sit on something hard and it just damaged the boat. Okay, and so really, using very simple language, if you had a mythical bystander beside that contract, what would he or she say? Well, of course we're going to put that into the contract. You know, it's part of the whole contract itself. You know, and now that was, I think, 1880s approximately in the UK. It was in London, and then we had the BHP in Shire of Hastings.
Sorry, that's the refinery where they had a discount or something along those lines, and when they sold or reorganised their business, the Shire said, no, you've reorganised it, so that gets rid of that discount. I think it was a discount or something along those lines.
Yeah.
I read it in that case book.
Yeah.
And of course, it went to court, and they said, basically, you can't expect a business to go 40 years, I think it was, without restructuring.
Yeah, good point. When a business starts, in the 1950s or 60s, I live in Melbourne. I used to go fishing down Hastings, so I know the area. It was a lot of bushland there, and you can imagine BHP taking a very large number of hectares there, and probably said to the council, look, ordinarily we have to pay X, but because we're newcomers here, we're bringing industry, how about we have half X? And, forevermore. Whatever. I'm making up as I go, but something to that effect. Now, probably for tax or other reasons, BHP XYZ Proprietary Limited transferred its assets to another company, and you'll learn that in tax and corporations law later on. They do that to restructure, to make it fit better. And they did that, and the council said, okay, you're going to pay full rates now. And the guy who did that probably was expecting a promotion for that. As it was, it went to the High Court. And I think he would have got a kick in the bottom and pushed him in the water to be fished out by the sharks, But the High Court looked at Moorcock, and it then prescribed 5 things that we need to look at, because it made it more clear and more objective. So let's look at them one by one. Who would like to do the first one? Michael, you have a go because Darryl just had a go. So,
all right, the term must be equitable and reasonable.
Yeah, what does that mean in plain English?
Reasonable and equitable, remotely fair.
Yeah.
And reasonable is just being, well, again, coming back to being fair. It's not, no one's getting screwed in essence.
Yeah. We don't want to stop business, but we want you to be fair. And if you want to not be equitable or reasonable, no one stops you from writing the contract. The parties reserve the right to be unreasonable. And I actually saw a contract from the Commonwealth once, and it said, we will not use good faith in this contract. Now, how would you feel if you read something like that? We will not act in good. I think it was something. Will not act in good faith. Anyway, so Darryl, give us the second one. That was what's the next one?
The second one's the term must be necessary to give business efficacy to the contract.
What happens if it's not necessary?
If it's not necessary,
Yeah.
That's it. That won't be implied then. That'll be something in the contract.
Yeah, exactly. Well done. And we had Scanlon's and Tui's case. Anyone remember the basic facts of that?
No, sorry.
Oh, that's the neon sign.
Oh, that's the sign.
Yeah, the neon one, isn't it?
Yeah.
And they, hi Jason, the Tui's, because they have a brewery, they wanted the sign up and they wanted it illuminated at night. And the judge said, well, you know, there is an event called the war which came around, but it doesn't stop the sign from being seen during the day. And said that it really has to be necessary rather than merely convenient. Okay. Anyone like to do this? Who are we back to? We're back to I think Daryl. I think back to you. The third one.
The term must be so obvious that it goes without saying.
Yeah, and so you can imagine you and I being on the wharf, and we see the moorcock severely damaged, and we say, "Jesus, that was bloody obvious." You know, how could these people not think of that? And if they did think about it, they would have said. The captain of the ship would have said, "Of course, I wouldn't have wanted to go there had there been rocks or something hard there underneath." And it needs, you know, it just needs to be obvious. Michael, what about the fourth one?
Must be capable and clear of expression.
Yeah. And in Anthony's lecture, he says something to the effect, well, it just goes without saying that this, you know, the court needs to be able to clearly describe. If you can't clearly describe it, you're in trouble. And Daryl, the last one?
The term must not contradict any express term of the contract.
Again, that's something we spoke about. Now, what we've done now, we've finished the first limb, two types of implied terms, those ones which give effect to the intention of the parties. And so that's the intention between the two parties. Now we're going to look at terms which are implied by law. Now, this is for various reasons they're implied, and we're going to look at this in two categories. One is the common law, and the other one is legislation. Common law has been around for a zillion years, but the legislation has just come in recently. So the first one, we had an implied duty to cooperate. What's all that about?
Well, if you're going to go and organise a contract, if you're going to go and do something, then it's in everyone's interest to cooperate. It's just implied to do so.
Yeah. An example also would be, I'm selling my business. I have a couple of cars, some equipment, whatever, and they are registered by the government because they have to go on the roads. An implied duty to cooperate is that I need to fill in the registration some transfer certificates. So say I forgot to give you those before, or you didn't ask. Now you're coming back for it, and I refuse. You know, that's the doctrine of cooperation there. Now the next one, the implied duty of good faith, which is an important one. Michael, I'll give you that one.
Basically, good faith being reasonableness and fairness.
Yeah. And tell us about Burger King and Hungry Jack's, because this is a case you really got to remember. It's a really a very important case.
Yeah, this is where Hungry Jack's was the operator here, and then Burger King wanted to bring their brand in, so they just kept rejecting their Hungry Jack's contractual demands of having to open X amount of new stores. So when the year was up and they hadn't opened the stores, they were saying they were in breach. So Hungry Jack's took them into court, and then it was found that Burger King acted in bad faith and prevented them from fulfilling their contract.
The other one was where the Hungry Jack's was trying to negotiate to get a Hungry Jack's store in, I think it was Shell service stations. And then the negotiations were broken off, and then Burger King went in. Let's take a step back. Up until the early 70s, yes, we did have hamburgers, because I remember as a child having them myself. But these were the Greasy Joe's ones. They were just a little corner shop.
Yeah.
But from a big multinational or large-scale business, the first, if I understand correctly, was McDonald's that came in. And not long afterwards, Burger King wanted to come in. Now, my recollection is that someone owned the name Burger King, so it couldn't do it. And in any event, it didn't want to do it by itself. it took on Burger King were the franchisors, and the franchisees would have been Hungry Jack's. Now, they have a head franchise, which means in plain English, they could do all the franchising, let's say just Australia and New Zealand. And then they would appoint people beneath. So everyone, the whole idea is in franchising, everyone makes a buck out of it. That's the whole idea. Now, in fact, Jack Cohen did such a good job out of all this. Burger King saw a significant part of their profits being lost, and Jack Cohen making them. He's becoming a billionaire. Well, it should be in the pockets of the Americans. And so they were trying to work out a way to get rid of him. And so they came up with this smart idea: is the contract needed, as you said, X number of stores needed to be opened. You being Hungry Jack's, you'd give me the number of stores. I refused them, and because I refused them, they weren't opened. Because they weren't opened, you were in breach of your contract, a literal breach of your contract, and we booted you out. Likewise, also, we stopped the negotiations between Hungry Jack's and Shell, and we restarted in our name, where you wouldn't get a percentage of the profits. And what did the New South Wales Court of Appeal say?
They rejected it.
Rejected it. Now, which court was it?
Business practice.
Which court was it?
It was in the
New
New
South Wales
Court
Court of Appeal. Now, have you all studied legal process yet? An introduction to law subject?
Yeah.
Yeah. So, how persuasive is a state case? How persuasive? Is it binding in New South Wales?
At the Supreme Court, or the appeals is binding in New South Wales to that level.
Yeah. And what about, is it binding? Is that case binding in Victoria, Queensland, Western Australia?
It's not binding, but they'll look at it.
Yeah.
It's persuasive.
Persuasive. Thank you, Daniel. So, in plain English now, what that means is that do we have a do we have a implied duty of good faith around Australia? We don't.
No, it's only New South Wales.
It's only binding in New South Wales.
This is a case that follows on from the Taco Bell in Sydney, and then Taco Bell America tried to come in. It's the same case.
Yeah.
That was just 20 years earlier.
Yeah, exactly.
Yeah.
So what the issue here is now, that's why we need a High Court case, because let's take our colleagues in New Zealand. It's one country without states. So a decision of their most superior court, or indeed a lower court, applies to the whole country because they don't have divisions like states. But we have them. It's an anachronism which causes no end of difficulty, and one of which is that a case which is well-reasoned case in one particular state is only persuasive. Now, if I was going into court and I felt that I was abused by this lack of good faith, and I was in a state or territory other than New South Wales, I'd be a little bit nervous. So in due course, it's going to go. I go to the High Court. I remember going to a seminar once, and this university professor, she stood up and she spoke about the duty of good faith. I was lucky. I lasted the first minute before I got lost. Others got lost in the first 30 seconds. And at the end of the hour, you know what she said? It's all too complicated now. If you really want an implied duty of good faith, you write it into the contract and make an express term. And I thought to myself, geez, you know, I could have saved an hour and however many dollars to pay for this thing if she just would have said that to me in the first place.
Then going down the pub.
You see what I mean? Is that's the problem we've got. And so therefore it's not, it depends on which state of Commonwealth you're in. So where are we? So as you remember from Anthony's lecture, he said something to the effect that the clauses of implied duty to cooperate in good faith are not there to get in the way of business competition. They're there just to bring some sort of standards, some decent standards to contracting. And there's a lot of shenanigans going out there. But you got to say the Burger King really is a good case, you know. And they're the ones, these blatant ones, have a better chance of success. But then again, if they were blatant, they probably wouldn't go to the court in the first place. Now, so they are two common law implied terms, but there is another couple, in other words, other ones. Can you rattle off a couple of the other ones? We have another
common law.
Yeah, no, common laws. In other words, they're not legislation. Over a period of time, they've been built up and they're implied terms. Someone said they're in the construction industry. What is the implied term? So, Daryl, I pay you and you do some work for me. There's an implied term if you're the builder. There's an implied term. Although we never so state it, there is an implied term as to the workmanship and as to materials. What would that be, those implied terms?
The workmanship and materials, that they're going to be adequate for the task and that you're going to do the job properly.
Yeah. But look, lawyers could describe that a little bit more eloquently, but at the same time, exactly as you said, that the materials will be more than fit for that purpose. They'll be of reasonable quality, and the workmanship will be of reasonable quality too. Something to that effect. And that's not unreasonable. Now, if in this case you're my doctor, my physician, I'm not feeling well, I go to see you. It's an implied term that you will use proper skill and care in your diagnosis. Or likewise in the dentist, if you're pulling a tooth out, etc., etc. So professional services have that sort of implied part. Building services included too. And when you think about it, a lot of them are pretty obvious. We've got here, I buy a TV and the thing doesn't work. That's an implied term for lack of fitness of purpose. In other words, said the other way, the implied term is when you buy something, it should be fit for purpose. I buy a car. Doesn't drive, or the thing's falling apart. That's not fit for purpose. Employment, the safety, my welfare as an employee, it's safe. I as the employee must take reasonable care whatever I do. I as the employee must not compete with my employer, take work away from employer, all that sort of stuff. In the construction area, if we build something, it's got to be fit for its purpose, that you can live in it. Same with a rental property, professional services. We've spoken about that. Okay. So what I wanted to do is talk about those terms which are implied as a matter of law are broken up into two. There are judge-made, and there are the ones by statute. Now the judge-made ones have been around for years and years and years, have come through. Now for various reasons, the government wanted to import to get statute. For various reasons, the government thought that some implied terms were not adequate, or it was too hard to imply them, and let's make them more clear. We'll talk about them next week. We've got state ones, fitness for purpose. We've got transactions. You've got some. I just forgotten. It can't be misleading, deceptive, things like that. It's on the state level and also on the Commonwealth level. And the main one there is Australian consumer law, and it's very substantial. And it's really imported from another different areas. So lots and lots of it's there. You know how I said to you not so long ago, we have all the different states and territories. They all had their own set of laws. What a headache. Now, as we're going to lead and go into the 21st, 22nd century, we really need to get our act together and work as a team, all the states and territories. So they brought the Australian consumer law. It's only been around 10 years. It's only took about 110 years to happen. But now we've got that. So we'll talk about that later on. But just remember, a lot of the stuff you can't, particularly the consumer transactions, you can't exclude. And we'll talk about that. And this afternoon I sent you an article on the new Small Business Unfair Contract Terms legislation. What that's all about is that previously, right from the beginning of the Australian consumer law about 7 or 8 years ago, people who got pushed around were those gymnasium memberships, telcos, airlines, stuff like that. They got pushed around big time. So what the government said, if there are unfair terms and you give them on a take it or leave it basis, the term could be plucked out of the contract as long as the contract can still stay. You toss the term away. Now that's now that foundation has been used for small business. So if you have a small business, is anyone in the small business there? Any of you guys in the small business?
Yeah.
I'm not.
No. Well, Michael, keep that in mind. Have a good read of that. And if there's any issues, just send me a personal email on that. Because what happened is that, and I don't want to pick on Coles and Woolworths, but it's an easy way to describe the situation. These big supermarkets have so much power. They go to Mr. and Mrs. Orchardist or Mr. and Mrs. Farmer, Mr. and Mrs. Dairy person, and say, we want to have that milk at 10 cents a litre. Oh, but it costs us 50 cents. Oh, I don't think you're hearing us. We'll pay 10 cents or we go down the road. Who else are you going to sell it to? Okay, we'll sell it for 10 cents. And so dairy farmers are just giving up. Okay. Now, the average person in Australia is really outraged by this, because they don't want to see this happen to the people by large corporations. And the government has acted. And what it's done is it's taken that unfair regime, which was really just for the consumer, like you and I in our personal lives, in relation to what I say, gymnasiums, telcos, airlines and stuff like that, and just expanded it and used the same basic framework and the same protections, but now in relation to small business. So if you are in a small business, it's something for you to really keep in mind. So whether you're buying or selling, as long as a small business is in mind, so that's the first of the three questions. The second is that it's got to be unfair terms. And if you can show us on a take it or leave it basis, then that is a candidate to have the clause plucked out of the contract. And then you're saved. But I'll leave it all up to you. But it's an important new one. All the other ones have been around for some time. Okay. So any questions before we start on our tutorial questions now?
That unfair one. I remember reading a report there, probably mid last year. Yeah. The Woolworths weren't paying their small suppliers on the 30 days. They extended it to 60.
Yeah.
And say, take it or leave it. We've now changed our system. You have to comply. So they're waiting 60 days to be paid.
Well, put it this way. I've got some inside knowledge in all this, but I just won't say much about that. But to say is that 60 days, they're lucky. They're lucky to get 60 days. We're talking about 90 and plus with a lot of these big places.
Mm.
They just say to you, so Michael's over there, and you say, Michael, you want to keep dealing with us? We'll pay when we feel like it, which is usually 90 days, something like that. So it's not too good. But if that interests you, have a look. It's a new law, I was talking to one of the authors, and he was saying to me that you can manipulate the system, the laws. That's why we have lawyers. It's there for organisations with less than 20 personnel. So Apple Inc. incorporated in the United States might make a subsidiary here in Australia with 8 people.
Mm.
Because it's under 20 people, there you are. The only thing, the difficulty with Apple is that it has reasonably modest limits, monetary limits before it peters out. But for Michael, unless you're dealing in millions of dollars, it'll be very good for you. But I, as a small business, I get it all the time. They point the finger at me and say, sign here. I say, I'd like to read it. He said, you would like to do what? I said, I'd like to read the contract. No, you don't. You just sign it. That's what I get all the time. And now it's actually quite good for me because actually when you think about it, you want to actually let them do that. And you have an evidence because not only do they say it, but you need to have some sort of evidence that they do it. So you just have some correspondence backwards and forwards. You only need to show 3 things. It's a small business, and there's a definition in the article. You'll have it. And the second thing is it's got to be unfair. And you can imagine there was a case just on the tip of my tongue. It's a cleaning company. They pick up the rubbish. The trucks go and pick up the rubbish. A major case. And what they had in their contracts is that they would change the price by themselves. They do horrific things. And the court said you can't do this sort of stuff. It's just unfair. And the third thing, it's got to be forced on you. And if you can show those three things, you have the benefit of the new unfair contracts, new small business unfair contracts legislation. Okay?
Yeah, we had
at least one side. Well, at least one side's going to be a small business. Sorry, Michael.
Yeah, we had one of the competition companies went broke, and they had 24 staff members, and they couldn't sack anyone to prevent themselves from going broke because they're over the 20 mark. And,
oh, jeez.
You know, so, I mean, there was more factors to that, but that's one of the factors, you know. Whereas if you had 18, you could just say, thanks for coming, you got to go, you know.
I'll just make this comment now because I don't want to dwell on it, because in fact it's something we're going to be doing next week. It's misleading deceptive conduct. But I run a tender and I say, Michael, how big is your firm? And you say 22 people, and therefore I'm confident these laws don't apply. And then later on you come and tell me the laws do apply. Well, I say, okay, well, you told me of something false when you applied for the tender. And this is how all the laws work together. See, in your studies, the most difficult thing, first of all, is learning an individual subject. I pick a finger. But later on, you've got to link the subjects together. And that's what a good lawyer does. And that's what takes them time. Look, the same thing with a doctor. They'll learn about, I'm making something, nerves and blood and bones and stuff like that. And then they're going to put the whole thing together in order to talk to a patient. And the same thing with us. We've got to do that as well. And so you're going to need to have a good understanding. Now, of course, you need to have an understanding of the core subjects. And there are a number of core subjects, one of which is contracts. And we need to know that very well because it's the foundation of all capitalism. Now, of course, if you become a refugee migrant lawyer, maybe contracts is not too important. But for a large number of lawyers, commercial is one way or another an important area. Okay, so what I'd like to do now is, sorry, unless there's any other questions.
No.
Let's have a look. And just remind me at the end, I just said I'd speak to Anthony about last week's question, so I'll just have a look at that. But just while they're there, I just wanted to show you this here. I don't know whether you can see it. This is a contract here. Can you see it? This is from 1553. That's 460 odd years old. Now, see the bottom? It's straight. See the top? It's curved. Why do you think the top is curved?
Didn't they tear the contracts once upon a time so that no two tears are alike?
Absolutely, 100% correct. Now, what you do is you get a big piece of paper and you write your contract. You divide it into two and you write your contract on the bottom of it. Then you turn it around and you write exactly the same thing on the other side. And then you get a knife and you cut it like that. Everyone see that?
Yeah.
Now, then you take one half, I take one half. Now, in years to come, we know exactly which one is a pair, don't we? We just fit them together.
Nice.
And those parts are called dents, like dentures, okay, like in your teeth. Hence, we call them indentures. That's where the name indentures came from. And that's how, in old-fashioned contracts, you can tell which was the other half of it. There's your history lesson for tonight. Okay, so just remind me to do the last week's question because I promised to talk to Anthony about that just before I forget. Okay, so let's have a look here, and we'll apply what we've learned tonight. Now, where are we? The question is, here we are, Lachlan and he's Tricia and Neil. Okay, so the first question is the facts. Always get the facts right. And I used to say I still say to people is that, look, it's absolute total crime to work hard and fail because you haven't read the question. If you're going to fail because you've been drunk for the whole semester term, that's one thing. But if you've been working hard and you fail, that's a criminal offence, you know. So what you do is you read the question a couple of times just to make sure you got the general gist of it. Now, I make a joke when I say this, but I'm quite serious about it. Woody Allen said, 70%, 80% of success in life is turning up. What do I mean by that? Don't be a perfectionist and go over and over and over again and then think, I can't submit this. Just submit it. Just do a reasonable job and submit it. Because I, as an examiner, look at things. If you got the basics, and I finished all your papers, I've just got to get the faculty approval. If you've done the basics, you will get a reasonable amount of marks. It's the extra marks on top of that which are hard to get. So if you only have a certain amount of time, do your contracts, do another subject. Don't overdo it on one subject and leave yourself elsewhere, because that's not a good way to plan your time. Know how the system works. Okay, enough of that. So Lachlan buys this computer, and Tricia agrees. And what does he get in return?
Just the monitors.
Yeah.
Yeah,
Right.
just the monitors, less the keyboard.
Okay. So how would you take that? He comes to you. Okay. So you're Daryl. You're a solicitor now. You've got a piece of paper behind your head there, and I come to you and I cry into my cup of tea and I say to you, look, I've got this such and such, I contracted, I went to, it's like going to JB Hi-Fi or going to her, I bought a computer and I got it without the keyboard.
Yeah, the computer's got to be fit for purpose. So it's got to have a keyboard with it, otherwise what's the point of having the computer?
Yeah.
Basically.
So let's have a look.
Just add something there.
Yeah, please, Daniel.
In the details, it was said that they talked about a screen size. So obviously the screen and the computer would be included, but there was nothing about a keyboard. So.
Oh, did I get the wrong one, did I? Here's me telling you to read the facts.
Yeah.
No.
She wasn't entitled to a keyboard. Lachlan, who wore custom meeting specifications, he gave a range of specifications regarding processing speed, graphics, drivers, memory capacity, screen size, and Wi-Fi capability. She said with no problem and quoted him a price he was happy with. Okay. A week later, she gave the computer, unpacked it, no keyboard. Okay. So what do we do now? And someone said, not fit for purpose. Let's try to bring in some of the stuff that we've been talking about tonight.
Customary, but
yeah, and I think, look, if you're writing an exam question, work backwards to see how much time you've got. I've just been marking these things here, and it's not appropriate for me to say too much, except that a number of people wrote 2/3 of their words for the first question and 1/3 of their words for the second question. It's not a good allocation of your time and your marks. And what I'm saying here also is look at the potential benefits, or potential clauses. In this case, would be implied terms, and pick a few out and discuss those ones. You can't do everyone, and in the court case, you can't do anything everywhere. So there is maybe we might say that we could use the ones. Where were we going? Just looking at my notes here. The cooperation, the implied duty to cooperate, that could be one of them. To finish off, lack of good faith could be another one. That's the Burger King one. clearly,
I'd use that one on Sunil, the lack of good faith. Handedness on that.
There's plenty of them there. Someone said before, fitness for purpose. You'll have the common law one, which is the default law, which swims out there. And on top of that, you have the statutory one. Because let's be honest about it, these things in law are pretty hard to work out. And for the average person on the street, it's hard for them to understand it. And if it's legislation, I know you're going to say it's still hard, but it's cleaner and neater. They don't have to ask what is an implied term. People understand rules in a book, and that's what basically the Australian consumer law is. It's rules in a book, fits for purpose. Okay, and then you might even say there is a in the Moorcock case, business efficacy. Good, you expect that. So what I'd say to you is have a number of those, and it makes a lot of sense in the sense that that if one cause of action that you're choosing doesn't work, well then you've got another one to fall back on. It's like you got basically a plan B to go ahead. And I think they're the ones that you could look at. The next one would be Sunil.
I can just go back to that one for a second.
Yeah.
I mean, I know we're not meant to really fight the question because we're doing these topics, but there is a specifications handed, and he is, as I call it, a computer geek, therefore would lean to a lot of these times these guys use existing things. He must probably still use the same joystick. Still must probably, like the whole lot of lists, So you go into Harvey Norman or whatever, you can buy it's not a Mac where it's in the screen. You can buy a computer whole unit or whatever they call them. So
the monitor.
No, not the monitor. The actual little. I've got an Apple, so I don't know PCs. I have the little tower. You can buy just something like that. So. So
I'm still confused. I'm still trying to work out what's the difference between nerd and a geek.
Hardcore.
I don't know the same thing.
Sorry, Daniel, what was that?
So basically, if he had considered that there wouldn't be a keyboard, then he would have expressly included it. But it's the fact that he didn't expressly include it, but he did include the monitor.
Yeah.
Well, let's analyse that. See, just let's work backwards for a second. The author of those questions, being Anthony, specifically made these questions borderline to bring out discussion. That's the whole idea of the tutorial. Now, I'm not computer literate. I just tap away. If it doesn't work, I call the Victorian roadside people, RACV, people who fix your cars. I make a joke when I said it. I call my IT guy up. So if I went and bought a computer, I would also have certain specifications because my computer guy would tell me, he said, you need this number of RAM and this amount of storage space and stuff like that. I might also specify the size of the screen, but I can imagine not mentioning much about a keyboard at all because to me, they all look, or they were reasonably standard. Reasonably standard. So that may not be conclusive, okay? But it shows good thinking. That's the idea, and that's the idea that bring all this out. But certainly things which normally need specification, if you didn't mention that, it might be hard to import them into the agreement. So unless there's anything else, we'll go to the next question. Our friend Mr. Sunil. Now, Sunil is an entrepreneur. He sees a business opportunity. And in fact, we could read questions B and C together because what does Sunil do to Lachlan?
Gets him to write a chapter on the area of his field of expertise.
And why did he ask him to do that?
As a diversion, because he had an idea of a business.
Okay, so let's take a step back now. Question B is about whether the agreement with Sunil includes any relevant implied terms, whether he should be paid $100. Now, can we stop Sunil from taking that secret away? Okay. Look, ordinarily, would you not agree there's no contract in relation to Lachlan and Sunil in relation to the confidential information? Because
well, I'd say that there'd be no a contract, but there'd probably be some intellectual property law there.
Yes. Now that's you beat me to it. What I'm leading up to is saying to you is that if we want to stop Sunil, we have to go beyond. Well, there is no contract there. We have to see whether the $100 contract had any bearing with it. You have to go outside. And Daniel, that's what you've picked up. There would be, it's called breach of confidentiality. And there's bits and pieces on that beyond the scope of what we're doing at the moment. But if we just stick to where we are at the moment, I'd suggest to you, or maybe, let's have a look at the contract, the $100 contract. So the facts were halfway down the page in 18. The following day, Sunil contacted Lachlan to offer him $100 to complete the chapter in the new book he was collaborating on for new online role-play gamers. The only problem was the chapter needed to be written within the next 3 days. Lachlan jumped at the opportunity. Meanwhile, Sunil went straight online and snapped at the business opportunity Lachlan had been discussing whilst Lachlan was diverted, writing a new chapter. Sunil then contacted Lachlan to tell him he didn't need the chapter after all, so there was no need for him to complete it. Lachlan only spent a few hours and he said, look, no need to be paid. Now, how would you argue using the Burger King case here? Would you?
Well, he's been underhanded he's come across an idea which wasn't his own, and being underhanded to take that idea so that he could jump on the opportunity, and also offering $100 just to get him out of the way. Yeah.
And so therefore, probably, that's why you've got to read questions or the facts of B and C together. The facts was that agreement with Sunil, there wasn't an agreement. He just told him about it. Mm. And if you left it by itself, you can't do anything about it, except as what Daniel said, is that there may be other ways you can do something about it in different areas. That's beyond the scope of what we're doing here. But what you need to do is be a little bit creative and have a look at the surrounding circumstances. A couple of weeks ago, we spoke about the fact matrix. In other words, just know what's happening, see how it fits together, and see whether you can put two and two together to make five out of that. Okay, and so in this case, what happened? We can say that the contract, the $100 contract, smells like dead fish, just as the Burger King case smelled like dead fish. When you look at it there. And the same thing, and you might be able to do something. You might be able to imply there that there was a duty of good faith which has been breached, causing damage, and in contracts B, you'll learn all about remedies. Okay? So therefore, B and C should be looked together. So the question B was whether this agreement with Sunil includes any relevant implied terms. No, there isn't, because there isn't a deal, there isn't a contract at all. C, whether he should be paid the $100 for writing. Well, he should be, because when he said no, don't need to pay me, there was no consideration, was there? No. So
consideration.
No consideration, and his loss is 100. His loss is not 100. You know, it could be substantially more. You know? So these are things we need to look at. So you would go through the different things we've learned. Now, the advantage of your big paper at the end of the semester, which is coming up, I think it was 12th of February. I just can't remember. I sent an email out to you today. The advantage of the big one is you have your notes in front of you, and just know the main headings, and sit down and just answer the question according to the main headings. Okay? I haven't written it yet. I've got a few things in the back of my mind, but I want to reward the people who came to the tutorials for their, for their diligence, and so the stuff we actually covered in the tutorials, I'll be using. Okay. So now, what I'd like to do is go back to the previous week, and I caught up with Anthony. We've lost Daryl again. He's run away.
Another gust of wind. It's hot up here.
So where are you now?
I'm in Cobbabella, west of Mackay.
Okay.
So you're inland, are you?
Yeah. About 150 k's inland, west of Mackay.
So what sort of temperature you got there?
Probably at the moment about 35 or so.
Oh, is that all? I went and did a job up in Karratha, and it was about in April or something like that, and I was about 35, and I said, "Geez, it's a bit hot here." The lady looked at me and said, "Are you some sort of wimp, are you?" I said, "What do you mean?" She said, "We get 50 degrees here in summer." I said, "It's not hot at all, you know."
That's all I have air conditioning.
Yeah. Okay, just to remind you, last week we had a Michael and Elle. I don't know what L stands for. This girl. So we had Evan and Elle. So this guy owned this house. He was going overseas, and he said to her, "You take over. You can be my tenant for a while." And so what they did is that they reduced it to writing, and they had 4 clauses in the contract. And I like this because each of those, there's a problem with each of those clauses. And so what we're going to do is have a chat about it now. Clause number 1, the clause reads as such: a clause in which Libby agreed to water the plants every day and to be liable for the plants which died whilst she was house sitting. Okay, and what happened is that you're only supposed to water this one plant weekly, but she watered it daily and damaged it. And so what do you reckon? Can you remember what happened there?
Yeah. That one I put down as clear and concise language as to what was required.
Yeah.
I could have argued the other way as well, because it doesn't mention anything about how much water you're supposed to give it. Like, it's a bit vague in that sort of regard. But I went that way, the clear and precise. It says to water the plants every day and that you'll be liable if any of them dies.
I just got some notes I scribbled down from our talk with Anthony. There are 2 parts of the clause. You've got to water the plants daily, first part, and to be liable for any plants which died while she was house sitting. And one party would want to keep it separate, and another party would like to amalgamate. So she tried to push that the second clause, the part needs to be read in light of the first clause. That and really, what he said to me is these questions are there to get the people to discuss. You know, it would be difficult in court to know how it go, because it depends on the day, it depends on the nuances, it depends on the person. But they're the sort of issues that you would look at. One which give you a bit more definite answer is, now remember, she was asked to collect the mail, and because she felt a bit pissed off that he'd got her to replace that plant when she had done nothing wrong, what does she do with the mail? She tosses it in the wheelie. Okay.
Hell hath no fury.
Sorry?
Hell hath no fury.
Well, she really did that, didn't she? You know. So now, what was her central obligation? Her central obligation was to empty the letterbox. The letterbox.
Empty the mailbox, yeah.
Yeah, box out. And that was it, wasn't it? Correct?
Mm.
That was a discussion we had last week, and rightfully so. But by her throwing the mail in the letterbox,
She's outside.
yeah. Now, what she's done is taking someone else's property, either destroying it or or moving it out of their possession. Taking someone's mail is a criminal offence, etc., etc. So that was not contemplated by the contract. Okay, but that's above and beyond the contemplation of that, and therefore what she's done is very wrong. She has indeed breached the contract. The next one is whether her termination was effective. Now, can someone tell me the law between conditions and warranties, what they mean?
Conditions and warranties, basically, if something happens, the condition is you might not enter the contract without this condition being fulfilled.
Okay, so using different words, a condition is a major term, an essential term. That's the whole purpose of entering into the contract. If we didn't, if you don't get that done for you, well, the whole thing's gone. The example I gave you last week was you hire a car and the CD doesn't work. And that's situation A. Situation B is the motor doesn't work. Now, that's clearly the difference between a condition and a warranty. And the condition allows you to walk away from the contract, which you should be able to because the whole purpose of the contract can't be fulfilled. Now, so when it comes down to the termination here, we need to look at what she's been doing. Is it a condition or is it a warranty? No. However, what they've actually done is they've written into the contract a codification here. Let's have a look. There was the third clause here was a clause in which Michael agreed that Libby would not be liable for any damage caused. Sorry, next one. A clause under which either party could terminate the agreement by email within 24 hours' notice. Now, can you reconcile conditions and warranties and the ability to terminate at notice? Let me say that again. The common law which floats around is the default law. If we don't say anything, that's the law we go to, conditions and warranties. The parties have said, no, we don't want that. We'll have our own way of doing things, and they write that in. Now, does that take priority or is that subsidiary?
It'll take priority because they've put it in the contract.
Because it's an express term because they've written it in themselves. Good, excellent. And so therefore, because that takes priority, the common law has been pushed to the side and we fulfill it. And so to answer the question, yes, what was the thing? A clause under which either party could terminate, and the question was G at the bottom there, halfway down page 18, whether Libby's termination of the contract is effective. I think she walked out. But basically, you can terminate because that is in the agreement, expressly in the agreement, which overcomes the common law because the parties have decided to do that, as long as it is by email and 24 hours notice. There's nothing stopping her from doing it by carrier pigeon, by telephone, by fax, etc. But you've got to follow the contract. The additional ones are okay, but the email and the 24 notices are mandatory. And the last one was whether she can rely on the exemption clause. The exemption clause is that clause at the top of the page 18, a clause in which Michael agreed that Libby would not be liable for any damage caused to the house as a result of electrical faults. And what Anthony said is that, again, there are two aspects here. Damage to the house, it must be a result of the electrical fault. Okay? Now, we spoke last week about is it within the four corners? And I remember we had a robust discussion. So you can have 3 or 4 people really whooping it up and smashing the place up, or you can have 30 people who are very quiet. So there is the number of people is not conclusive. But if you had 300, of course, I think that gets a bit over the top, you know. But where does it stop and where does it start? That's an issue. And also, how many times did you do this? On the facts, it's only happened once. And is there any reason why a person couldn't have a bit of a party and just hire someone around for just a bit of fun? If I was her, I'd say, I didn't know he was going to come and bring all the stuff and burn the joint down. Okay. So therefore, the issue is we got to look at the actual term of the contract. And the contract says here, would not be liable for any damage caused to the house as a result of electrical faults. Now it's up for you to go through, and let's have a look 1/3 of the way down the page 18. The following Friday night, she arranged for a dozen friends to come over for a girls' night. In the course of the evening, a paid entertainer visited for an hour and connected a stereo, a smoke machine, and some disco lights to create the right atmosphere for his performance. Unfortunately, these items overloaded the electrical system and caused the fire, ... Now, overloaded, is that the same thing as caused as a result of electrical faults?
I'd put that one down as it's different.
Yeah.
Because it's introduced electrical equipment that you don't know how it's been maintained.
Exactly.
You don't know, like basically he had no knowledge of it even turning up. I mean, disco lights, who uses them?
Are you asking me a question?
Yeah, I just got amazed. Like, when I saw disco lights, I thought, crikey, I haven't seen them in a long time.
But what happened if, I'm not an electrician, but you have these safety switches where if it's overloaded, it trips. Now, if that didn't work properly, I mean, if he had one, which is good because houses should have it, but if it didn't work properly, I'd suggest to you that was a result of maybe a result of an electrical fault. Okay, but I think it's stretching it to say that this guy has come along. So I don't think she can hide behind that exclusion clause. So what she should have done out of prudence, or the person who organised the entertainer to come and had an agreement with them, and also had made sure they had insurance. Okay. Now, so what the owner of the house would be doing is be having a go at her and the entertainer. Now, this makes it interesting because what happens if there was an agency? So the agency has entertainers and has a dozen different categories of entertainers, jugglers and et cetera, et cetera. And she said, tonight I'd like this stripper to come around, this guy to come around. No. So we got that. So she pays $400 and the guy gets $200 and the agency gets $200. So who's the contract between? It's between the purchaser, which is our friend Libby, and the agency. Now, the agency should have made sure that all the electrical stuff is properly tagged, et cetera, and insurance there. And then, so you could have a go at him as well, and you do that in negligence. I seem to recall last week talking to you about the distinction between negligence and contracts, which you'll do in great detail at a later stage. But just simply, if Daryl, you're my employee, and there's a machine, I buy the machine and you work the machine and you're injured. Now, you can't sue the manufacturer because there's no contract between you and the manufacturer. The contract is me because I bought the machine or the car or the truck, whatever. And so, but I'm not the one who was injured, you're the one. So you would have a go at me for safe workplace, etc. And also you have a go at negligence, breach of duty of care. And these are all the things you need to look at. And so indeed, if you're in private practice or you're a corporate counsel in an organisation, you need to consider these risks. And I do a lot of that sort of stuff. And you need to think it through. What I normally do is I do diagrams on the walls. And you might remember at the beginning of the year, and I remember seeing it today, and I'll just pull it out, is this my little diagram here, is you have these ones. Like that. And I remember I had a client once who rang me up and said, can you do a risk analysis? I said, yeah, okay. Send it over to you. I saw it. It was 1.5 pages of closely typed. I'm going to kill this guy, And I had a look at it, and I thought, oh, what am I going to do? It only took me half an hour. It was actually quite good because I drew a whole series of diagrams like that, and I linked them all together. And in the middle of each one, you have buyer and seller there. So in the middle of each one, I put a number. I had 10 contracts, and I linked them all. And then I had a piece of paper, and I put the contract number, what the risk was, how we're going to overcome it. And it actually became straightforward, as long as you can see in your mind how all the contracts fit together. Okay, so I wasn't going to do much more than that. Any questions tonight?
Could I just ask, with the four corners rule?
Yeah.
Because like that conduct of the party wasn't specified in there, could she be liable for something outside of a contract law? Like, because like that as her damaging his property, not even in the context of the contract, could that possibly?
Well, she might have a situation negligence where you have a duty of care. But Daniel, I'm glad you brought that up, because something I forgot to say is that you might be pushing it to say it was outside the four corners of the contract. The four corners of the contract are, while not clearly so stated, it would be that the tenant would take care of the property, they wouldn't have huge parties, they'd mow the lawn, and just be nice stuff like that. She could argue, look, I just had a couple of girlfriends over, we just had a drink, watched a bit of TV, we just decided to have someone come around, we moved the furniture back, but we didn't do anything. I think if it was explained like that, I think you could still be within the four corners. You could argue. But if there was 30 people, and we've had this a couple of times, and there was a bit of whooping up there, and the windows so got smashed, or a few drunks and a lot of red wine spilled, you could argue outside the four corners. But let me say this to you, Daniel. I thank you for picking that up. I just say to you this is tradition. The law is traditionally hard. That's why legal fees are high. That's why you never can tell exactly where the person's going to win. If I said you got a 70% chance, that's almost like saying you got a 100% chance, because there's always going to be a degree of, you don't know what's going to happen. It's really. Just to finish off, my own background, I came from the sciences, and I became an accountant, and I was very used to rigid, clear boxes, like the engineers and people like that. That's the way they think, and that's the way I used to think. And when I came to the law, I had two difficulties. I used to read a lot of cases, and I found the English a bit difficult. It's a little bit like Shakespeare, a little bit more English stuff. And it took me a while to get used to it. Then I got used to it. But the second one, which took me a long time to overcome, was the difficulty in not having things nice and neat in boxes. It's still into a way to now still have that, but you'll have it floating, and that's why there'll be in court cases, after a while, one party will go and talk to the other party and just say, look, how about we settle this matter, right? And that's why 9 out of 10 of these disputes don't end up in full resolution. So a lot of them actually, they start the court case, but they don't finish it. They'll just finish. One party will realise it's all costing too much, or they're going to lose, or the risks are too high. I had one just the other day. I was talking to a colleague of mine about they were doing really, really well, and I thought they're going to win. I thought, well, look, we don't want to push our luck. Lady Luck has given us this fantastic position at the moment. There were great riches at the end, but they didn't know what was going to happen. So the other side knocked on the door, and a very generous settle offer was made, and they just took it. Okay, because they didn't want to take the chance. And you'll always have something which lurks in the background which can damage your case. It's like every time you drive your car, it's potential being damaged. So Daniel, that is a very long-winded way.
No worries.
Have I answered it? Probably not.
Yeah, you have.
Yeah. But anyway, look, what I'm trying to do is for the regulars who come here who talk to me, but also I notice half the class watches in. That just to give you a bit of a background how it all fits together, because if you just walked into it, these are the rules, 1, 2, 3, 4, 5, well, that's all very nice. But I personally found it hard to remember these things. So I always put them in context. How does it fit together from the historical viewpoint, from the business viewpoint? And then it actually begins to stick, and you get it all working together. But everyone's brains are different, and that's the way it works with me. And that's why I do these ones here too, these flow charts, because I find them extremely easy just to run your eye down. Take a bit of time to do it, but I don't find them very easy. Okay, look, next week, we're getting near the end now, but have a look at the Australian Consumer Law. Don't overdo it. Just have a look at it. When you go to a shop between now and next week, the Harvey Norman type shop, ask them what happens if it's not fit for purpose. Ask a few questions like that. Have a look at your rights. Now, under the common law, the law which floats around, we have guarantees. What did I say before? Fitness for purpose. But we have some of these guarantees are a little bit hard to understand, and so they're just being dumped into the Australian Consumer Law. Bang, 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 bang. But if for some reason that Australian Consumer Law doesn't, for some reason it doesn't apply, there'll be a state equivalent. And if that doesn't apply, you've always got the common law to help you out. All right? So once again, wish you all the best. Any last minute questions?
Nope.
As I said, I finished all the papers, and I'm just waiting for a couple of things, and I hope now on Saturday to get some information and send them off. Okay? So all the very best to you.
Thanks.
Thank you.
Bye-bye.
Yeah.